A few words on the civil liberties of the female sex. Claim C0. All acts of allowing women to vote or hold public office are individually contrary to divine law, because all such acts are contrary to the divine law that the husband and father is by divine right the head of the family, and the family is the foundation of the state. Claim C1. Any and all laws which fail to deprive even unmarried women of all the following species of civil liberty: the liberty to own property, the liberty to inherit property, the liberty to serve as guardians of even their own children, the liberty to make valid contracts, the liberty to sue or be sued, the liberty to claim legal compensation for injuries, the liberty to give testimony in a court of law, are just as mad, ill-founded, and wicked a folly and impious and irreligious, against God's divine order of creation, at least in kind if not in also degree, as is the allowance of woman's suffrage. Theorem. Claim C0 implies claim C1 not just for adult married women, but even for adult widows. Proof. According to C0, the family is the fundamental unit of society, and that by divine order, authority in the family belongs to the husband/father alone. And C0 makes the claim that this implies that it is contrary to divine law for women to vote or hold public office. Implication C0a. C0 grounds all public authority in patriarchal family authority. If the only divine model of authority is husband equals ruler, wife/children equals subjects, then every attempt to give a woman personal civil liberty in her own name undermines the very premise. 4. Such liberties grant personal legal agency to her apart from the husband/father, which disagrees with the absolute headship claim. Owing property in her own name equals she is an economic head in her own right equals contrary to C0a. To sue/be sued in her own name without consent of her husband equals she stands as a juridical person equals contrary to C0a. Contract, inherit, or serve as guardian equals executive or custodial authority parallel to male headship equals contrary to C0a. Woman's testimony is received in court equals autonomous, in judgment equals contrary to C0a. Ergo, the same principle that excludes her from the suffrage would have excluded her ipso facto from all of these above civil liberties. Why suffrage is not a special case? If divine order denies women public authority, it also denies them private authority, since the private household is the basis of the state. The husband headship must be exclusive and comprehensive, political, juridical, and economic. Ergo, every liberty that places women in a position of personal civil liberty in Indiana, her own name, would have been equally impious against the same divine order. Therefore, C0 implies C1. That may have been true for married women, but here is how it can be proven for adult widowed women who don't remarry. 1. What C0 says. C0 rests everything on this. The order of the family is the blueprint of the order of the state. In that order, authority belongs by divine right to the husband and father. So the foundation of political authority equals paternal headship. 2. What happens if the husband dies? If the husband dies, then two things happen. The household still exists, children, dependents, property, etc. But the head by divine right has disappeared. If divine law give the headship to the husband qua husband, then a widow cannot by divine right take his place. She is not a husband, not a father. That means either the family ceases to have a proper head, a contradiction in C0's framework, since the family is a cell of political order and must have a head, or authority must pass to some other male substitute, e.g. adult sons, brothers-in-law, or the state acting in loco patries. 3. Consequence for widows. On C0's logic, a widow cannot become juridically independent in her own right, because that would mean she is head of the family, which C0 denies is possible for a woman. Therefore, she cannot claim property as owner in her own right. She would merely hold it as trustee for male heirs. She cannot act as guardian of her own children, since guardianship equals paternal office. She cannot contract, sue, or testify as an autonomous legal agent. If she did, then she would be assuming the very kind of authority that C0 says belongs by divine right to men alone. 4. Historical confirmation. Historically, widows often had dower rights, a limited life estate, in their husband's property, but this was framed as maintenance, not ownership. Custody of children often passed not to widows, but to male relatives or the court. Widows needed male guardians in probate and property matters in many jurisdictions. This was precisely because jurists and legislators were still trying to square the circle, how to let widows survive without making them heads of households in their own right. 5. Logical link back to C1. Thus, if C0 is true, then even a widow cannot be granted real civil liberty. Any law that treats her as independent contradicts the divine right order. Therefore, C0 implies C1 even for widows. All women, whether married, single, or widowed, must be deprived of civil liberty. Conclusion: C0 leaves no escape hatch for widows. If C0 is true, then widows are either wards of their male kin or wards of state, but never autonomous heads of households. To admit otherwise would be to deny the very premise of C0. Ergo, C0 implies C1. QED,